Ladies and gentlemen, dear friends and colleagues, welcome again. Good morning, everybody. Start a little late, sorry for this, but now we are ready to listen from Professor Pinto, welcome in Trento, and from our colleague and friend, Dottoressa Sartori, some issues about criminal law. This morning we will have two differentiation. The first one, criminal law, and the other as for consumer law. Then we will have a coffee break, and our friend Professor Izzo will be the chairman of the last session of the morning. In the afternoon, we will have a workshop just to discuss some opportunities for commercial trade between Italy, and especially Trentino, and Brazil. So, Professor Pinto, we are discussing about criminal law, national and international dynamics. And the floor is absolutely to you. Please just speak about maximum 30 minutes, no more. Thanks a lot.
Buongiorno. Innanzitutto vorrei ringraziare l'invito e scusarmi per il ritardo. Faccio anche i complimenti ai colleghi di Brasile e a mia moglie che riesce a fare tutti gli ostacoli piccoli come questo che abbiamo avuti sulla strada. E siccome ho un grande affetto per l'Italia e per gli italiani, assumo il rischio di parlare in italiano. Chiedo le scuse per gli sbagli con la lingua, ma ricevono non come un'offesa questi sbagli, ma come un sforzo di dimostrare la voglia di ringraziare l'opportunità. Ho scritto un articolo che non sono riuscito ad aprirlo in mio computer, ma io tengo le topici, le punti, e dopo lo faccio pubblico per tutti. Voglio parlare un po' della violenza, dell'economia, del diritto penale, della procedura penale. Dopo l'11 settembre, l'attentato negli Stati Uniti, cominciamo a vedere un atteggiamento in tutto il mondo di combatto al terrore, ma anche un atteggiamento pessimista, un atteggiamento di controllo, apocalittico, che ha promosso varie modifiche nel diritto, specialmente nel diritto penale, specialmente in Brasile. Oggi in Brasile si vede molto un discorso, si sente molto un discorso in cui la violenza tentano controllare la violenza per il diritto penale. Hanno creato un rapporto innocente tra il combatto alla violenza e le leggi penali, il diritto penale, le sanzioni penali. Ci sono due leggi specialmente importanti, anche perché raggiungono a affettare l'economia, una che fa il combatto o che tenta fare o che che hanno creato una pubblicità di che questa legge farà il combatto alla criminalità organizzata, specialmente al riciclamento di denaro. Riciclaggio? Oh, riciclaggio di denaro. E un'altra di combatto ai tangenti. E tutti e due, quello che si vede, è un ingenuo discorso che offre come strada di combatto a questi illeciti, il diritto penale, e una cosa un po' peggio, che è un stimolo e alcuni obblighi anche ai cittadini di essere quelli responsabili per l'appurazione, i civili, i particolari. Un atteggiamento che si trova negli Stati Uniti. Non solo sanzioni a quelli che non partecipano, che non aiutano, ma anche alcuni stimoli. Così si vede una trasferenza di quello che deve essere il monopolio dello Stato. Se sbaglio troppo o se loro non riescono a capire, per favore dicono che posso cambiare per l'inglese. Sì, va bene. Capiscono? Sì, no, ma capiscono? Sì. Queste due leggi di cui ho appena parlato, o su cui ho appena parlato, sono nuovi atteggiamenti che dimostrano il tentativo di controllo dello Stato sulle persone, sui rapporti sociali, e che non raggiungono a ridurre neanche la violenza, non ridurre la violenza neanche i reati che si propongono a ridurre. A Milano, quando sono arrivato in Italia, ho visto una telecamera con un segno su che diceva per la protezione delle persone e per la tutela del patrimonio. Questo vedo come un segno di che l'atteggiamento è mondiale. Un Stato che per combattere o per vendere il sogno del combattere del combatto della violenza offre controllo. Violenza che c'è varie facce, che deve essere il combatto alla violenza deve essere per vari politici pubblici, ma che oggi in Brasile si vede solo per il diritto penale. Per esempio, un alcolico che aggredisce sua moglie. C'è in maniera chiara un problema di salute pubblica. In Brasile l'alcolico è un malato, ma oggi si vede solo per il diritto penale il problema. Anche la criminalità organizzata, che in Italia c'è una storia, una lunga storia. Possiamo, per lineare il raziocinio, il pensiero, possiamo vedere quel del brigantaggio, quando Re Vittorio Emanuele ha riunificato l'Italia, e la mancanza di politici pubblici di politica pubblica ha permesso lo sviluppo di una criminalità organizzata. Peço le scuse perché è un'affermazione così semplice per un problema che per noi e per voi è un problema troppo significativo. Ma la criminalità organizzata ha un spazio per svilupparsi quando non si offre opportunità per le persone lavorare in modo ufficiale, in modo lecito. Eugenio Raul Zaffaroni, quello penalista argentino, dice in modo felice che il problema della criminalità organizzata è un problema di economia disorganizzata, senza organizzazione. E quando le persone dicono in Brasile che un bambino, un giovane, fa una scelta di lavorare in modo illecito, trovo questa affermazione in modo assolutamente insensibile e senza un pensiero razionale. Una persona che non riesce a vedere fuori di se stesso, perché in Brasile quelli che optano per aiutare il traffico di droghe, il commercio di droghe, lo fa perché non ha condizioni di scelta, non ha proprio un'educazione formale di qualità. E ho trovato in altri congressi in cui ho partecipato in Europa, specialmente in Portogallo e Spagna, che i numeri di Brasile, le statistiche, creano una realtà diversa e per molte persone che hanno il contatto con Brasile per il numero possono pensare che noi abbiamo una situazione molto migliore di quella in cui viviamo. Veramente troviamo un sviluppo dell'accesso formale all'educazione, dell'accesso formale all'impiego, ma non sono veramente un sviluppo, perché la scuola è diventata una scuola senza riprovazione, così tutti riescono ad essere di questa scuola. Hanno creato università dove non ci sono professori per raggiungere i posti, università pubblici, hanno difficoltà di occupare questi posti di professori, ma ci sono università. E anche hanno creato alcuni impieghi come quello di call center, che è il primo impiego di molte persone e che non sono propriamente impiego in cui la persona riesce a diventare un professionista. Così ci sono varie situazioni che il numero crea un maschio della realtà. Abbiamo oggi una popolazione senza educazione e cultura, che non riesce a capire i suoi diritti, per questo accettano una condizione subumana, accettano anche questo deficit di democrazia, perché accettano che il diritto penale sia il risposto per il combatto alla violenza. Quando ho parlato su il riciclaggio di denaro. In Brasile oggi una persona che ha un negozio e che quando fa una vendita si percepisce che il compratore non ha condizione di fare questa compra, deve fornire le informazioni alle autorità ufficiali. Lo stesso paese che discute varie leggi per sanzionare la discriminazione. Così c'è uno Stato che obbliga la discriminazione perché sono segni esteriori che fanno in modo che il proprietario del negozio pensi che la persona non sia proprio una persona in condizione di comprare quel prodotto. Altrimenti si sviluppa quelli collaborazione dello correo. In Brasile si chiama delação premiada ou collaboração premiada. Quando uno investigato aiuta dicendo le circostanze e anche altri possibili responsabili, come una violazione alla ormetà. E domando, e con questo voglio camminare per il fine, ma questo mi fa domandare a me stesso. Lo Stato non ha un limite per imporre il suo controllo, non ha un limite etico. Perché dico così? La cultura degli Stati Uniti oggi è una cultura di paura. E le persone si vedono a se stessi una come un nemico d'altra o potenziale nemico. Quando lo Stato comincia a creare meccanismi di appurazione che esigono che un particolare agisca in modo a responsabilizzare, in modo a fare pregiudizi agli altri. Questo fa in modo che io, come cittadino, inizio una paura, un odio di tutti, perché non so chi sarà il mio nemico. Non possiamo lavorare con quel raziocinio semplice di buono e male. Quando si parla di appurazione, di processo, di ricostruzione della realtà tra le prove, non possiamo semplicemente parlare di bene e male. Dobbiamo invece pensare in democrazia, nei limiti. E oggi lo Stato, con l'obiettivo di ridurre la criminalità e la violenza, penso che crea un scenario pericoloso in cui le persone perdono la capacità di fiducia nelle altre persone. Questo per me è lo peggio di questa intervenzione. Ma non possiamo dimenticare e fare un piccolo accrescimo alla lezione di quel che non lo trovo come penalista, ma come un filosofo politico che è Cesare Bonesano, quando dice che lo importante è la certezza della sanzione e non i rigori. Questo oggi è poco per la complessità della società. Quando lo Stato dovrebbe punire, deve pensare nella effettività prima del rigore. Ma mai la punizione può essere la prima risposta alla violenza. Perché Brasile è oggi la terza popolazione carceraria del mondo e questo è un lusso che un paese povero non può darle. Così, se non per un raziocinio di diritti umani, dobbiamo pensare in questo problema del diritto penale per un raziocinio utilitarista. E quando si dice così, con questo scenario, vari penalisti cominciano a difendere le sanzioni alternative, sostitutive. Ma questo non è una sanzione sostitutiva, questo è il fine del diritto penale, perché il diritto penale c'è come marchio la sanzione, che legittima il processo penale con tutte le garanzie che abbiamo. Queste garanzie sono troppo quando la sanzione non è una sanzione di prigione. Un'ultima osservazione per finire. Oggi questa complessità che l'intervenzione penale crea in Brasile, ci siano varie spese nuove ai negozi, ai professionisti, come assicurazione contro indennizzazione, assicurazione per pagare gli avvocati, e questo tiene come fine ultimo, quello che paga al fine è sempre la società. Così, per finire, solo per chiudere il raziocinio, quello che avrei voluto, non so se sono riuscito a portare, è una situazione che penso che non sia una situazione che si vede solo in Brasile, ma in Brasile, negli ultimi anni, si vede lo sviluppo del diritto penale come una maniera di negare la missione dello Stato in effettivare politica pubblica e la negazione non è l'unica conseguenza negativa, perché questa intervenzione senza il limite proprio comincia a affettare i rapporti sociali tra le persone e anche crea nuove violenze, nuovi problemi, senza risolvere il problema che la legge ha promesso di combattere. Così finisco, ringrazio l'opportunità, l'invito e chiedo le scuse per gli sbagli e grazie.
Grazie, Professor Pinto. Thanks a lot. We will discuss your presentation. I have a lot of questions for you at the end of the morning. Now, Daria Sartori, University of Trento, the floor is up to you. Yeah, the question just at the end of this, also for Professor Pinto. Okay, at the end of this first session, so we will discuss. So please, Daria, 20 minutes for you, no more. Thanks a lot.
Funziona? Sì. Grazie, Federico. First of all, English or Italian? English, it's better? Okay. Good morning, everybody. Thank you for the organization of this conference. Thank you for the organizer, and thank you for being here to our guests. Today, I will talk about the influence, the effects of the Europeanization process on the domestic criminal law of the EU member states, and the effects on Italy especially, from the point of view of the general principles of the criminal law mostly. So, as we know, the basis, the foundation of the modern criminal law in all the Western civilizations can be found in the Enlightenment. And what I personally believe is that the Europeanization process is comparable to the Enlightenment for being a real revolution which is going to shape the criminal law, transforming the modern criminal law in contemporary criminal law. And when I talk about Europeanization, what I mean is not only the process, the progressive merger of markets within the EU, so the creation of the European area of freedom, security, and justice, the common market. But what I mean is also the creation of a common Europe of rights, of human rights. Because usually when we talk of Europeanization, we refer to the process which took place starting from the 50s, after the Second World War, starting with the integration of the markets in Europe. But what we must not forget is that Europe is also a process of internationalization of human rights, let's say, creation of international constitutions, such as the European Convention on Human Rights, such as the Charter of Fundamental Rights and Freedoms of the European Union, which is now a binding text within the EU. And what we derive from this new revolution? Well, the revolution represented by the Enlightenment brought limitations to the state powers. So for the criminal law, it was really important because it was humanizing criminal law. It was bringing limitation to the absolute state powers through the principle of legality, mainly, which we all know is a principle which is valid for the substantial criminal law, procedural criminal law also. And the interesting thing is that the Europeanization process is modifying, is affecting the principle of legality as we know it from the Enlightenment. But if we think properly about it, what is going on with the Europeanization is still a kind of limitation of the state power. So first we had the Enlightenments with limitations to the state powers coming from the inside of the state. The same sovereignty of the state decided to limitate its own powers in criminal law through the principle of legality, through constitution, the creation of democracies. Now, what we see is like a correspondent process where the limitations come from the outside. Because from the outside, what we have, the influence that we have from the Europeanization is that, for instance, there are certain rights and freedoms that pertains to EU citizens that cannot be the object of criminalization. Or what we have is the duty of the state, of the member state, to legislate in criminal matters on certain areas. Even now, we have Article 83 of the Treaty on the Functioning of the European Union, which allows the European Union to legislate directly in criminal matters, like in order to establish minimum guidelines, but still it is direct legislation from the EU in criminal matters, without even going through the legislative process at the domestic level. So we have external limitation coming from the outside, but thank God we don't have only negative effect, we have also positive effects, because these limitations include also human rights. And among these human rights, we have the principle of legality. What is interesting, in my opinion, is to understand that this principle of legality at the European level is different from the one that we are used to think about when we talk about criminal law after the Enlightenment. But it's different. It's not like, in my opinion, like mine is a neutral adjective that I'm using. It's different. It's not necessarily bad, like wrong. And it is different because, of course, the courts that shaped the principle of legality at the European level, the ECJ and the European Court of Human Rights, they are courts that they have to operate at a level which includes also common law jurisdiction, not only civil law jurisdictions. So it is normal that the principle of legality, as they built it, was not including, for instance, what we call in Italian riserva di legge in materia penale, which is the duty for the criminal law to be produced by the parliament, by the representatives of the people's will. This is not part of the notion of criminal law, of the principle of legality in criminal law at the European level. And what is interesting is that even if it's not part, the case law of the courts, the European courts in general, is not necessarily less guarantistic for the citizens, in my opinion at least. It has shaped some principles, such as the ne bis in idem principle, which before the intervention of the European Court of Justice was only considered a principle within the frame of the national state, and now it can be considered an international principle, voiding the double prosecution of a crime in different states, which means within the European Union, right now, the case law of the ECJ is going in the direction of saying, if one member state is prosecuting and condemning a person for one crime, then another member state cannot do the same because it would be violated the ne bis in idem principle. And this is something really new because until now, from the Enlightenment until now, the ne bis in idem principle was only valid within the state and not within international relationships. So there are some peculiarities which in my opinion are like going to provide better protection. Just a final remark. The attitude of the Italian highest courts, of the Italian Constitutional Court and of the Corte di Cassazione, it is interesting to see, let's say, because it is an attitude of closure, especially from the Italian Constitutional Court, because at the level of declaration, let's say, the Italian Constitutional Court refuses limitation to the sovereignty of the state, which is so profound as it is now going, like the Europeanization process is now going. So, for instance, the human rights protected by the European Convention on Human Rights, they are considered as sub-constitutional sources of law. Still, the Italian Constitution prevails over international instruments of human rights law. So the Italian Constitution, with its notion of legality, prevails over the notion of legality promoted at the European level. However, at the same time, we found many interesting judgments, both by the Italian Constitutional Court and by the Corte di Cassazione, which are going, let's say, in the direction of a kind of common law model, let's say, because they start to recognize, they started actually like already in the 70s, but to recognize the idea that interpretation might also be a source of law, which is the basic idea behind the notion of legality promoted at the European level. They are starting to recognize, for instance, the non-retroactivity of changes in the interpretation of the criminal law, which is something really interesting because for our understanding, civil law jurisdiction understanding of legality, legality only applies to the law in the books. For the European notion of legality, legality also applies to the law in action, which means non-retroactivity of a change in the interpretation of the law if it is against the interest of the defendant, criminal defendant. And this is something that is now slowly finding its way, let's say, in the case law of the Italian Corte di Cassazione. So to have some conclusions. What I think is that often we criminal lawyers tend to think too much by staying in the categories that are being shaped by the Enlightenment. What we have to understand is that the Europeanization process, we cannot block it, we cannot fight it, and up to a certain point, of course, we can criticize it, but we have also to understand that might be more useful to try to understand the positive effects that it might have, rather than focusing only on the negative effects. And in order to do that, we have to look at the case law, because there is no possibility of joking here. It's like all is going on in the Italian criminal law, in the shaping of the contemporary Italian criminal law, is due to the Europeanization process, is thanks to the case law of the Italian courts, domestic courts, of the European Court of Justice, of the European Court of Human Rights. So it is there that we have to look at. And these courts are all, let's say, having a dialogue between them. There are a lot of books talking about judicial dialogue between courts. So, yeah, so thank you very much for your attention. Thanks.
Thank you, Dara. You are such perfect as for the time. And so we have about 10-15 minutes just to discuss Pinto's and Sartori's presentation. Any question? Absolutely, yes.
Thank you to both speakers for these interesting presentations. It seems that the two speakers are looking to criminal law from different perspectives, or at least they work on different planes. It seems that Professor Pinto is talking about criminal policy, and Dr. Sartori is talking about the more positive law aspects of the evolution of criminal rules subject to the Europeanization process. But I think that it could be very interesting to bridge these two presentations talking about reciprocal influences. That is, from a Brazilian point of view, and this is my question, and maybe also Dr. Sartori has some insights about this. From the Brazilian point of view, what kind of attitude or what kind of perception is there about the Europeanization process of criminal law? Or better, how the increasing influence of the international level of rulemaking production in criminal law is perceived in Brazil? Do you think that Brazilian criminal law could be also influenced to some extent by these international developments and also by the European developments?
Thank you, Professor. No, scusa. No, perché come in Svizzera ho parlato con una persona in spagnolo, dopo in francese, e non sono così capace di cambiare. Stamattina ho tentato pensare in italiano quando la mia moglie ha cominciato a parlare con me, ho pensato in italiano così, ma noi in Brasile abbiamo una maniera diversa di controllo internazionale di diritti umani, perché per noi il controllo è fatto dalla Corte Interamericana di diritti umani, in cui l'accesso non è diretto ai cittadini, come qui in Europa. E non so se il nostro mezzo è meglio, perché ci sono c'è un accesso più difficile, ma c'è una effettività di discussione maggiore, che qui in Europa ho sentito parlare che la Corte ha cominciato a avere troppo lavoro, e così ha una difficoltà di rispondere a tutte le domande. Ma è vero, specialmente nel diritto penale c'è una influenza che mi dispiace che la nostra autonomia ci sarebbe data per il processo civile, perché prima del 1869, quando Bilov ha creato la teoria del rapporto giuridico, noi abbiamo in Prussia, quando Federico II, imperatore di Prussia, e anche Caterina II in Russia, quando per influenza di Cesare Bonesano, della scuola dell'illustrazione, hanno proibito la tortura come mezzo di prova, possiamo percepire prima di un secolo, comparato con Wilov, la nostra autonomia. Un'autonomia che viene dai diritti umani, non viene dalla creazione di tecniche o di categorie come la nostra storia, la storia che ci è data. Così in Brasile è una situazione di paradosso, perché oggi si vede una discussione intesa del sviluppo, del rigore, del controllo, una maniera strana, perché la protezione per il diritto penale non protegge, è una maniera di vendita. Lo Stato dice così che prima io soffro un danno e dopo ricevo una protezione, non c'è più protezione se c'è stato il danno. Ma c'è questo scenario di sviluppo del controllo, sviluppo dell'intervenzione, ma anche c'è un discorso crescente, specialmente nell'ambiente universitario, della necessità di sviluppare anche il rapporto tra il processo, principalmente il processo. Sono professore di procedura penale, così la procedura penale è quello che si dice la maniera più sensibile di vedere quale stato che ci sia. Così il bisogno di creare questo rapporto tra diritto penale e procedura penale con la struttura di protezione dei diritti umani. Ma questa discussione ha ricevuto un aiuto dalla Corte Costituzionale, la nostra si chiama Supremo Tribunale Federale, quando hanno considerato antigiuridici la prigione del depositario infidele, come quello che riceve in deposito un bene, come dico? Custode infedele. È considerato una prigione che viola la Convenzione Interamericana di Diritti Humanos, la prigione del custodio infidele, che si dice? Sì. E nella stessa discussione hanno concluso che tutte le norme di diritti umani non confermate sul Parlamento, ma firmate per l'esecutivo, non sarebbero norme costituzionali, ma sarebbero norme sopralegali. Così oggi formalmente tutti in norme di diritti umani in cui il Brasil ha manifestato l'appoggio, sono norme supralegali. Questo dimostra che le norme di diritto penale, di procedura penale, devono osservare sempre specialmente la Convenzione Interamericana di Diritti Umani. Un esempio che è impiegato in Brasile è il diritto a non essere testimone di se stesso, invece di soltanto il diritto al silenzio, come negli Stati Uniti c'è un'ampliazione che viene dalla Convenzione Interamericana dei Diritti Umani. Così ci sono le due facce nello stesso momento in Brasile.
Se posso, volevo aggiungere solo, in effetti è molto interessante perché è simile alla situazione che si è venuta a creare in Italia quando la Corte Costituzionale ha dichiarato che i diritti tutelati dalla Convenzione Europea dei diritti dell'uomo hanno questo rango che è fra la Costituzione e le fonti primarie, che appunto per quello io dicevo prima, no, l'importanza di guardare anche agli aspetti positivi di questi fenomeni di internazionalizzazione, perché ci sono diritti più ampi che vengono garantiti solo grazie al fatto che viene riconosciuto a questi strumenti di diritto internazionale un ruolo che è al di sopra della legge prodotta dal Parlamento, che anche se democratica non necessariamente è la migliore. È quello il discorso particolare, diciamo, dell'internazionalizzazione, secondo me, sì.
So, thank you very much indeed. Professor Pinto and Dr. Sartori for your presentations. And another, sorry, I don't see you.
Siccome nessuno vuol parlare, vorrei fare una domanda alla dottoressa Sartori. Lei ha parlato abbastanza sul principio della legalità, cui effetti garantistici mi sembrano abbastanza modesti. Io vorrei pensare, non so, io sono molto meno ottimista sul ruolo del diritto penale. Io vorrei chiedere il principio della proporzionalità, della ragionevolezza nel senso più complesso, non soltanto la ragionevolezza tra pena e condotta, comportamento, però la ragionevolezza come un controllo profondo della capacità del diritto penale di proteggere beni giuridici e della necessità di un intervento penale e non di un intervento amministrativo civile. Cioè, questa prospettiva europea ha una preoccupazione sul garantismo più profondo, più sostanziale, che sarebbe, ho letto varie cose sulla europeizzazione del diritto penale, mi sembra che il principio della ragionevolezza nel senso della dogmatica costituzionale non sta presente in questa. Io vorrei ascoltare la sua opinione.
Well, I agree with you, I think, yes. Yes, there is a problem there, of course. It is also true that what I was talking about was the extension of the guarantees for the criminal law, meaning that it is true, I agree. Like right now, we are in a moment, especially in Italy, like in our system, we are in a moment where the criminal law is improperly used in many areas where the criminal law could be avoided. And the international dynamics in general are often favoring this phenomenon. Yeah, this is true. However, on the other side, the force of the legality principle as conceived by the ECJ, the European Court of Human Rights, lies exactly in the fact that the definition of criminal law is so broad that it actually covers with the guarantees of the criminal law many areas that, according to the law of the member states, are not criminal law. What I mean is that if we agree that like the European Court of Human Rights has created some criteria to identify what is criminal law, the so-called Engel criteria. They have been taken also by the ECJ, European Court of Justice. And according to these criteria, it is not important whether in the member states one fact is classified as criminal offense or not. What is important is that other requirements are there. And on this basis of the new broad definition of criminal law, we apply all the guarantees. Like, what I first thought when I looked at this was exactly what you said, is like the expansion of the criminal law, which is actually a worrying phenomenon. And as Professor Pinto was saying, also criminal law is often used improperly as a mean to, especially a mean to reinforce politicians and to give the impression that we are doing something for the war on terror. We are like, yes, that's true. But on the other hand, like the great force lying in the Europeanization process, I think, is in terms of human rights. And in terms of human rights, extending the guarantees of the criminal law outside the criminal law is not bad. That is my understanding of it. I hope I answered your question somehow.
Io ho avuto l'opportunità di domandare al professore Alex. Non ho potuto fare registrare la domanda perché la mia amica, professoressa Monica, non mi ha dato la parola nel congresso, ma ho potuto farlo solo con lei. Lei ha detto che la legalità impedisce quello che lei ha creato come costruzione di proporzionalità. Ma la legalità, penso come lei, non è il principale nella discussione della proporzionalità. Nella procedura penale c'è un principio che è un principio esclusivo della procedura penale, che è il principio della presunzione di innocenza. Questa è una ponderazione fatta dal legislatore. In tutti i momenti in cui ci sono i dubbi, questi dubbi devono raggiungere nella libertà. Così io non riesco a vedere una situazione. Oh, scusami, c'è una situazione quando c'è una vittima con rischi futuri. Così si può pensare in diritti individuali su potenziali conflitti. Questo conflitto. Altrimenti, l'unica persona che può essere affettata dall'azione ufficiale dello Stato è il polo passivo. Così non si può pensare nella struttura basica di una ponderazione nella nostra area. Quello che si fa in Brasile, che si chiama, e è un altro problema, nella prospettiva della filosofia del linguaggio, che in Brasile si chiama, il Supremo Tribunale Federale chiama insignificante, o principio della insignificanza, un'altra cosa. E anche la proporzionalità in Brasile è usata come una maniera di si creare o di si applicare un diritto diverso di quello che c'è, ma un diritto che il giudice vorrei che ci sarebbe come legislazione, un cambiamento di legislazione nel caso che non è nunca una struttura di proporzionalità.
Okay. No more time for any more questions, sorry. Now the floor is for Professor Marcelo Milagres, and we are talking about the meaning and effectiveness on consumer protection in Italy and Brazil. Thank you a lot very much to be here, Professor Milagres.
Okay.
Please? The title is in Italy and Brazil, but before Brazil.
Okay, you have to shift.
First, I would like to thank the kindness of honorable invitation of Professor Giuseppe Bellantuono and Dean of Faculty of Law, Professor Giuseppe Nessi, also Professor Federico Pupo, Professor Sartori. Also thank you, Professor Paola Iamicelli, with whom I shared this panel. The meaning and the effective consumer protection in Italy and Brazil. I organized my talk in two parts. The first, a history of the organization of the consumer defense system in Brazil, highlighting the importance of a conventional market, sinks, and immaterial market goods. This is inclusive of my research project at the Federal University of Minas Gerais, where proprietary law studied the corporeal to incorporeal. The second issue is the discussion of the concept of consumer and bills to amend the Brazilian Consumer Protection Code. I believe the essential improvement of techniques, the active, both the now market, with the movement of material things, as the contemporary market, circulation of intangible property. You need to think about the tangible and intangible. I didn't have, and I haven't, the purpose to exhaust the topic, but just start a good exchange with professors of this prestigious university. The concern with balance of consumer relations is relatively recent, can be attributed to now excess and deviation of economic liberalism. A society of mass consumption in the mid-20th century already suffered from some negative standards. For example, economic concentration, captive and abusive contracts, irregular investments. Finally, there remained a number for new sales techniques that do not consider the recipient of this complex and multifaceted production process, the consumer, as a subject of rights. Sweden, in 17, as the pioneer, introduced the figure of ombudsman and consumer class court. France, in 1973, promulgated the famous Howard Law. The United States had great contribution and recognition of consumer rights with the famous message of President Kennedy sent to Congress on March 15, 1962, according to which we are all consumer process, thus diffused the need for instrument of regulation and effective protection. In Brazil, until 18, lacked the systematic, consistent approach and technique of consumer relations, subsisting laws with implication for consumption, but lacked a specific protection law and consumer protection. In 1985, relevant was the contribution made by publication of law 7,347, 1805, which exceeded the modern interconservative and designing for settling conflicts between individuals' interest to active collective and diffuse interest. It was a relevant instrumental of Brazilian class action, pertinent to a society of mass consumption. A quite important contribution is this historicity of defense and protection of consumers' interest, Housewife Association in my state, Minas Gerais, and yet it's worth to mention the creation of important civil entity of consumers. In July 1987, that's it, the Brazilian Institute for Consumer Defense. However, only with the Constitution of 1988, consumer protection was raised the category of fundamental rights, as well as the fundamental principle of legal and economic order determined the Article 48, the Temporary Constitutional Provisions Act, drew up a Code of Consumer Protection, which remains covered through Law 8078-19. The first aid Code of Consumer Protection, alongside established contemporary regulation of relations of consumption, provided for the national policy on consumer law and the national system of consumer protection. The national policy on consumer relations, founded on several principles, aims to harmonize the interests of participants of consumer relations and the compatibility of consumer protection with the need for economical and technological development. For implementation of this policy, the CDC provides for the participation of various public and private entities, integrate the so-called national system of consumer protection. According to CDC, these articles 105 and 106, part of SNDC, the Secretary of Economic Law, the Ministry of Justice, through its Department of Consumer Protection and Defense, and another federal, state organs, federal district, municipal, and a civil organization for consumer protection. The PDC is coordination body of SNDC policy and acts specifically in the case of national importance and matters of greater interest to the consumer class and development initiatives to improve the system to consumer education and better information and influence consumers. There is no hierarchy relationship between the PDC and the other members of SNDC. The Department of Consumer Protection and Defense has only the coordination of the national system of consumer protection. There isn't a hierarchical relationship between the agencies and organizations that defend and promote the consumer, because constitutionally this activity fits our federal entities and the full exercise of the jurisdiction concurrent nature. In the context of the competences defined by federal model, PROCONs are state and local consumer protection agents created under the law, specifically for this purpose, with powers in their regional or local powers. The Brazilian Code further provides relevant chapters on basic consumer rights, quality products and services, business practice, contractual protection, administrative sanctions, criminal offenses, and consumer protection in court, highlighting advances in treatment of tort, contract advertisement, and contempt. Protective efficacy of third parties or external effectives and credit end, notably the good faith as a fundamental principle in consumer relations recognized, even with distrust Harris himself, but oriented frustration of legitimate expectations entails responsibility, particularly the relationship between unequal. In negotiation development, high importance denominated attachments, side or instrumental debts, such as loyalty, honesty, transparency, clarification, care, protection, collaboration, and cooperation among several. A breach of these and another debts can set positive break of contract. The incidence of good faith as a normative source of creating legal obligations, not just limited to negotiation phase itself, but extended to the phase of qualified social contact, and also the post-negotiation phase. In over 20 years of the Code of Consumer Protection, much progress has been made. It stands out even intense dialogue with the Civil Code, but indubitably, the big change was cultural. The majority of the population recognized the CDC as an instrument of citizenship. Some challenges, however, persist. How to effect a regulation of consumer relationship in the face of intense speed and economic of many services. The concept of customer itself remains a subject of intense debate. In Brazil, the courts have decisive contribution in the building this policy, expand and restricting the extension of the concept of consumer, who among us rich entity. Contemporaneously, the acquisition of products seem to be overcome by the use or enjoyment of service. Are commercialized ideas, images, concepts, access, consumer credit to technology. The discussions are added. Unlike the Italian Consumer Code, the Brazilian service defines as active provided in the consumer market for remuneration. The notion of ownership is overcome by the complex relationship of accessibility. Intangible overlaps the matter. The intangible seems to be the characteristic of marketing in which social relationships present themselves as commodities. But the dot-com generation coexists with the generation of the product, the thing's body. The various manifestations of consumption deserve different approaches. Research project under development at Law School at Federal University of Minas Gerais, I propose a discussion of the economic rights in a plural approach. Recognize the many, old and new, the exercise domain in development strategy of the democratic state law, promotion the accessibility of the subject of law to various assets, ensuring their forms of protection and building new rights. There is need for promotion of consumer relations, involve more primary and essential goods, as well those that are part of dynamic, growing, and endless technological era. Two worlds coexist. New and old rights overlap. There are electronic, dematerialized, and borderless market. But there is a market for things and geographically limited. The pursuit of systematization cannot ignore a complex and changed reality. Part of this reality is the subject of legislative debate. The Bill Senate paragraphs 281, 282, and 283, and their substitutes are meant to update the CDC, reach issues of electronic and distance commerce, collective action, mechanisms of conciliation and mediation, consumer credit, prevention on over-indebtedness, the great problem in Brazil, over-indebtedness, harassment consumption, misleading and unfair advertising, sustainable consumption, national register of collective process and civil investigations, and commitments of behavior adjustment, adoption of punitive damage. In this current time, even discusses the scope of state action in opposition to the autonomy of economic agents. Power would consider the possibility of the experience of private arbitration in consumer issues. The Senate Bill number 406, 2013, provides in the Article 4, Paragraph 3, such a possibility. Forward or backward. In times of overcome borders, there will be a model of defense policy and consumer protection, and specifically resulting from the experiences. This also seems to be the challenge of the Italian model, whose normative defense system and consumer protection, especially legislative decree 206, September 6, 2005, is the integrating continuous for extended and community principles. All ascertain. In times of speed economy, in which of intense and dynamic range of service is the keynote of hyper-competitive market. Even from the perspective of suppliers, the continuous satisfaction of consumer expectations is more than a challenge. It is a merit of survival of the capitalism model. Thank you.
Thank you very much indeed, Professor Milagres. And now the floor is for Professor Iammicelli, and we will discuss both presentation and the end of this morning. Please.
Thank you. Thank you, Federico, Professor Pupo, and thank you to the organizers of this conference and to all of you for being here, part of this very helpful discussion. Thank you in particular for the previous speaker to prepare the floor to many keywords that I will use as well in my presentation. Well, coping with the time limit, I will try to tackle 4 short points. If I cannot make all the 4, you will forgive me. I will first tackle the issue of legal foundations of consumer protection in the European Union and Italy. Second, I will deal with the scope of consumer protection in our legal system. Third, and maybe more important, the modes of enforcement, which I would like to focus some consideration also for the debate and for the comparison with the Brazilian system, and then just a few concluding remarks and hints for discussion for the debate to come. Okay, just let's start from the legal foundation for consumer protection in Europe and in Italy, moving from the consideration you have just explained to us nicely that in the Brazilian constitution there is an express reference to consumer protection. Okay, this express reference doesn't exist in the Italian legal system, although, I mean, in the view of some scholars, Article 41 stating the limit of the freedom of private initiative within the limit of social utility, human dignity, and freedom may be referred to as a general limitation, also including consumer protection purpose. Of course, that article, whose implications are very much debated between among scholars and practitioners, well, goes well beyond consumer protection. But that is maybe the only possible reference we may have in the Italian constitutional charter. However, we do have, as we know, an Italian consumer code, which is in force in Italy since 2005, been having antecedents in other laws, pieces of law in previous legislation. And Article 1 of this consumer code explicitly refers to constitutional principles and European treaties. Now, as it was already recalled before, among these European treaties, we also have the incorporation and the binding force of the European Charter of Fundamental Rights, and Article 38 expressly recognizes consumer protection as a binding commitment of the European Union institution before the public. So in this sense, we may conclude that in Italy as well, although indirectly, although implicitly, there is a constitutional coverage for consumer protection as exists in Brazil. And I have found some similarities in the debate at the Italian and South American, Brazilian level, trying to derive from this constitutional coverage some implication in terms of the social function of private law. And in the case of consumer law, it would particularly mean social function being based on accessibility, and in particular accessibility to justice. But I will go back to that when I will deal with enforcement mechanism. Let me go to the second point about the scope of application of consumer law. And when I say consumer law in the Italian system, I pretty much refer to the consumer code. Now, it's important to underline that consumer protection law is not confined within the limits of private law. Of course, we have heard a lot about constitutional law, administrative law, even criminal law, international law. These are all fields very relevant for consumer protection law. But even within private law, it's not easy to find a specific area traditionally intended of private law, consumer protection law, because even there, we have a kind of functional approach to consumer protection that aim to provide for high level of consumer protection. This is what is stated in Article 38 of the European Charter of Fundamental Rights. Well, this implies a functional approach for which no one single field of law would be sufficient to tackle this target. Well, so even the consumer code cannot be targeted as or labeled as like contract law or tort law. The divide between contract and tort laws tends to blur in this case. What is the focus then, the scope of consumer code? Well, it is nicely described in Article 1 of the consumer code with reference to the purchase and consumption process. This is the focus. It's a process. It's also a new language in the law. What is purchase and consumption process? Processi di acquisto e di consumo. This is something that crosses contract law, tort law, pre-contractual regime, post-contractual regimes. So that's why I'm referring to this kind of functional approach to consumer protection law, which is pervading the all parts of the consumer code, from part 2 devoted mainly to education, information, commercial practice and advertisement, to part 4 devoted to product safety and quality, but even part 3, which should be in the view of a contract lawyer as I am, the main contract part of the code. Even there, the subject matter is not the contract as an act, if more the contractual relationship in its dynamics, it's in its several dimensions. is the Relazione di Consumo, which is the title of this part 3. And at the core, what is important is the issue of accessibility. We could say that among the main purposes of this legislation is the aim to facilitate consumer access to market in all the several forms this access may occur, and limiting the several obstacles that may hinder such access. Okay, let me bring two comparative elements, looking at the same time the Brazilian and the Italian law, hoping that I will not make mistake, but you will correct them, of course, in terms of scope of application. First, like Brazilian law, the Italian legislator has not extended the application of consumer protection in favor of legal entities. Second, in a very recent reform, 2012, a part of consumer protection law about unfair commercial practices was, by contrast, extended to micro-enterprises. Just to be clear, micro-enterprises defined at the European level as an enterprise which comprises less than 10 workers and produces less than 2 million turnover. This is very general, very generic actually statement, just to give you an idea. Okay, I don't want to go into depth with that. I think that there are many critical issues about this non-extension in the first case and extension in the second case. It could be debated whether it is preferable or not preferable to do that. I would be very interested in understanding, for example, in the case of Brazilian law, which implication the extension to legal entities has brought. I think there is some space for debate about this aspect. But before going there, I would like to say something about enforcement and effective redress. We have spoken about effectiveness before. I was very interested about that part of your presentation, which also thank you for. Well, also in consumer law, enforcement and effective redress remain pivotal, remain very important aspect of consumer protection. Data collected through European Consumer Service show that the percentage of consumers aggrieved by unfair practices or illegal conducts who resort to enforcing authorities is still very limited. This may be a difference with the Brazilian system, where we have heard yesterday that access to justice is tremendously abundant. Now, what is the reason? I mean, and there are many reasons. Time limit cannot allow us to list them. But of course, one of the concerns is whether the mechanisms in force are really effective. So there is an issue of effectiveness. And there is also another aspect of European Union law which should be considered when we speak about enforcement, because there is a general principle dividing the competence of the European Union institutions and member states institutions, inspired to the principle of procedural autonomy of member states. So the procedures for enforcement are competence, are matters for competence for member states, whereas the definition of rights may belong, I mean, at a certain level, of course, to the European Union. Of course, this distinction may generate some incoherent result and some loopholes in terms of effectiveness. This is why European institutions, including European Court of Justice, have many times confirmed that the principle of member states' autonomy in defining the procedure is subject to the principle of effectiveness. So these procedural rules stated at member state level should exactly be effective. And we do have a lot of case law. There's a very recent case discussed by European Court of Justice where a Spanish person was deprived, was evicted of his home family house before a declaratory judgment could declare the unfairness of the term of a mortgage loan agreement on which basis the seizure of the house was put into action. So when the declaratory judgment was there, it was too late because the home, the family home was already evicted. That was an example. That is an example of total ineffectiveness of a procedural rule and effectiveness of the substantive right also, because that was a violation of a European directive on unfair terms. Okay. There's also a lot to say about the effectiveness of procedural rules, when we come to a specific subject, which is collective redress. So the possibility to adopt enforcement mechanisms that satisfy at the same time a collectivity of a group of consumers. As we may know, the European institutions have intervened with a number of provisions and documents in this area. There is a directive, especially on collective redress in consumer protection from 2009. There are more recent initiatives in 2013 with the communication and then a recommendation about collective redress, this going beyond consumer protection area, not only on consumer protection specifically. So there is a lot going on in this subject matter. But let me, before coming to the conclusion, let me just give you some more elements about new trends in enforcement mechanism in the Italian legal system, also about collective redress. And I will focus on two aspects before concluding. The first one is the increasing role played by the competition authority in the enforcement of consumer protection. The second one is the role for consumer organizations, which you also were referring to, or consumer groupings in bringing actions for the protection of collective or homogeneous interests, which are not exactly the same things. First, the role for competition authority. Okay, I can list a number of legal reforms about unfair commercial practices, about unfair terms in standard contracts, about even the latest Consumer Rights Directive 2011, which was transposed into Italian law only in 2014, just a few months ago. Okay, in all these fields, the competition authority has obtained increasing powers to intervene in the enforcement of consumer protection. How? Particularly with the investigating powers, so including ex officio investigation and inquiry about all these practices, with the power to issue injunctive orders, so injunction to suspend or to interrupt, to cease and desist unfair practices, and of course the power to issue fines, monetary fines, against enterprise who will consider liable. One important piece of novelty is in the 2012 reform about unfair terms in standard contracts, which is about the right actually, of the enterprise to submit to the competition authority in a preventive way, so ex ante, before the use of standard terms, the contents of standard terms, in order to get the approval of the competition authority. This is very important because this is a kind of preventive measure in order to reduce the phenomenon of consumer infringement. And of course, there is an important aspect to be considered, that if a term is approved, the competition authority cannot have a power anymore, of course, to inquire about the practice ex post. But on the other side, the judicial intervention is always a possibility for the consumer. So when I speak, and this is the point I want to make about the role for competition authority, this role is very important, but it is not alternative to the judicial intervention. It's only complementary to the judicial intervention. So the high level of protection of consumers is always there. There is a new element to be added, but it's not a substitution. Then the other piece of novelty, and that I really come to the conclusion, is about judicial enforcement of consumer protection, about not only the role I said of the consumer organization in bringing actions before a court in the interest of groups of consumers, which may prove to be very effective in terms of reduction of costs, for example, and increase of effectiveness of the measure that is enacted in this case. But I also want to make a reference to the so-called class action which was introduced in the Italian system in the latest years. It became effective only in 2010 after many years of debate about how it should be framed. And still today, it's very far from being perfect. Well, we count a number, not so many. I didn't have the complete list, but I think they are not more than 6, 7, 10. I don't know, maybe some has better figures. Procedure that are in course. In the latest 2 years, I think 3 of them at least have had positive answers for the consumers, so the claim was accepted by the judge. However, the procedure is very complicated, and access to justice is very critical. Just to give you an example, one of the latest procedure was closed a few months ago. It was about bank violation by a bank, and among 104 consumers who could participate to the procedure, only 4 got redress. So this is, and the reason why the claim for the others was rejected was mainly procedural, because they failed in filing the complaint correctly. And this is the proof that there is a lot of ineffectiveness in the procedure. So probably the idea is good, but the way it is enforced is very far from being perfect. Okay, I come to the concluding remarks. I think that's looking in a comprehensive way to presentation. I think that there are a lot of common challenges faced by both Brazilian and Italian consumer law. In some substantive terms, the enormous potentials for the digital revolution that you mentioned need to be tackled, not only to enable consumers to exploit the several opportunities brought in terms of increased accessibility to market, but also to adapt consumer protection, then I need to refer to enforcement, to the speed and pervasiveness of possible abuses and risks of unfairness, and then the fostering the collective redress response. I think it is the most important thing to be done. Now, the role for public and private regulators in defining best practices besides spotting violations is definitely relevant, but at the very core, enforcement is the key. In its multiple dimensions, from moral suasion to recommendation, to correction and injunction, and of course, if it is needed, monetary sanctioning. Now, the comparison between the Italian and Brazilian systems, if examined, I would say, well, beyond the scope and the limits of this contribution, which is, of course, very limited, may also help to address an institutional issue which can be debated here about the level at which these challenges should be addressed. Regional, federal or interstate, global, or maybe more correctly, which type of complementarity should exist among these several levels of consumer protection. I thank you for your attention.
Thank you very much indeed, Professor Iamencelli. I think that we had 2 great sessions this morning, many suggestions, and I think we will have a good debate at the end of the morning. Now we have a 15-minute break, and there is a coffee for us just on the right side upstairs in Sala Giustino D'Orazio. 15 minutes and then start another time. Thank you.